Very good. It is 10:05 on January the 7th, 2021, the first meeting of the year for the Texas Department of Licensing and Regulation Motorcycle Safety Advisory Board. Good morning, everybody. I'm Presiding Officer Keith Rovell, calling the meeting to order. I would ask everyone to please mute your microphones, only turn them on when you speak, and please announce your name when speaking. We'll call on Delia Luna now to please do the roll call.
Thank you. Jeffrey Alford.
Present.
Jude Chexner. Snyder, I'm sorry.
Present.
Kyle McNew.
Present.
Michael Manser.
Present.
Commander Robert Richmond.
Present.
Ricky Wyatt.
Present.
Chris Litvin. Roger Bowles.
Here, present.
And Presiding Officer Keith Rovell.
Present.
We do have a quorum.
Thank you, Delia.
You're welcome.
Yeah. Moving ahead now to item C on our agenda, we're going to be talking about training for advisory board members. And we have Derek Burkhalter, the Assistant General Counsel, on to take that for us. Derek?
Thank you. Good morning. I'm Derek Burkhalter, the Assistant General Counsel for TDLR, assigned to this program. So today we are going to do your annual refresher training as to the laws that apply to your service here on this board. We did this back in February when you were first assigned, but that seems like a lifetime ago at this point. So this is just kind of a reminder of all the laws that apply to you. So I am going to try to share my screen. And can everyone see that?
Yes.
Okay, great. And okay, so as I go along, if anyone has any questions, please just go ahead and speak up. I can't necessarily see you while I'm sharing my screen, so I won't be able to see if you have a hand raised or anything like that. Okay, so this training is going to cover 3 different portions of the law: the Open Meetings Act, the Administrative Procedure Act, and the Public Information Act. And we'll start with the Open Meetings Act. So the purpose of this act is to ensure open and transparent government. The act requires meetings of governmental bodies to be open to the public and to be preceded by public notice of the time, place, and subject matter of the meeting. And the act's provisions are mandatory and are to be liberally construed in favor of open government. So if there's any gray area, we err on the side of transparency. So just a few key concepts that you need to know. The idea of a quorum is a majority of the members of the advisory board as fixed by rule or statute. So you have 9 members, so a quorum would be 5. A quorum of the governmental body must meet in order to take an official action. And if less than a quorum meets, the board may have discussion but may not take any official action. So as we've met in our work groups since our last meeting, we've had less than a quorum of the group, which doesn't violate the act, and we haven't taken any official actions. We've just had discussions that we'll present to the full board today. The next concept is deliberation. A deliberation or discussion means a verbal or written exchange among a quorum of a governmental body or between a quorum and another person concerning an issue within the jurisdiction of the governmental body. And a meeting occurs anytime a quorum of a governmental body engages in deliberation regarding public business or public policy over which the body has supervision or control. And it looks like Mr. Litvin has joined us now. Okay. So Delia, it looks like all of our members are present at this point. So I'm just moving on. The next concept is notice. The act requires advance written notice of the date, time, place, and subject of each meeting. And TDLR provides this notice in the form of our agenda. And this agenda is filed with the Texas Secretary of State's office at least 7 days before a meeting and must be posted online by TDLR and the Secretary of State. And this board may not engage in discussions about a subject that's not included on the agenda. So if discussions kind of stray from the agenda items, then I may have to sort of, interject and ask that we stay back. So we often get the question, what about social functions, conventions, and workshops and things like that? Keeping in mind that a meeting occurs whenever a quorum engages in discussion. Can members ever meet in an informal setting without violating the Open Meetings Act? And the answer is yes. Members are free to engage in conversation that is incidental to any of these events. However, the discussion will be subject to the Open Meetings Act if a quorum is involved and the members engage in discussion or make decisions about board or committee business or take formal action. So if there's some sort of motorcycle association meeting and 5 or more members of this body are present, that's okay. You can talk to each other. You just can't talk about the business of this advisory board. So you can talk about the business of the association you're attending, just not business of this body. So always be aware of any situation occurring outside of a properly noticed meeting in which a quorum of members is present or engaged in discussion. And again, do not engage in substantive conversations relating to business or policy when a quorum is present and you're outside of an official meeting. And beware the walking quorum. And what that is, that occurs when fewer than a quorum of members engage in discussion about official business, and then those members communicate those discussions to other members who were not present for the initial meeting. So while fewer than a quorum of members participate in the initial communication, subsequent communication with other members can result in a quorum discussing business outside of a public meeting. So in other words, if you have a meeting with 3 other members and then you email a 4th or 5th member about those discussions, that would be a walking quorum. So you have to be very careful about who you talk to about our work group meetings and things like that. So for example, on a 5-member advisory board, 2 members exchange phone calls and emails expressing thoughts on an upcoming rule change and exchange research that they have each individually performed regarding the issue. And then one of those board members subsequently forwards the exchange to another member, and now the members have engaged in a walking quorum. So that's just kind of an example of how that can happen. And walking quorums can occur during conference calls, video conferences, hallway discussions, emails, text messages, and other new technologies such as Twitter, Facebook, instant messaging. So you really have to be careful about what you post on Facebook or any social media, because that can be seen by other board members. And if they post anything, we could have issues with that. So the best advice really is don't discuss official board business on social media. Just a few points of advice. Do not meet in small groups and then communicate those discussions to other members. Do not send emails or text messages to a quorum, even if each email is addressed to individual members. Again, be careful about what you post on social media where other board members could be reading it. And do not ask a quorum of members, even on an individual basis, for feedback or comments on board business outside of a public meeting. This is called polling, which is essentially conducting an informal vote on an issue. This board is limited to discussing the specific items on the agenda, as I've already said. During the public comment portion of the meeting, which we will have today, members of the public are given an opportunity to speak, and the presiding officer may set reasonable limits on commenters. I believe we normally have a 3-minute limit that we impose. A member of the public or a member of the board may raise a subject that has not been included in the agenda. However, any discussion of the subject must be limited to a proposal to place the subject on the agenda for a future meeting. To avoid violating the act on the basis of insufficient notice, members should limit discussions to the specific agenda items contained on the agenda. avoid allowing discussions regarding specific agenda items to wander off course, and should not respond to or discuss issues that are raised during public comment, but which are not on the agenda. So if someone does make a public comment today, you can ask clarifying questions if you don't understand their comment, but we can't really engage in a back and forth discussion with them. We can't answer their questions and those sorts of things. And members specifically identify issues for future agendas and communicate those items to TDLR staff. We normally do that at the end of these meetings. There are some penalties legally for violations of the Open Meetings Act, civil remedies. Any interested person, including the media, may petition the courts to stop actions that are taken in violation of the act. And the act states that an action taken in violation can be voidable. So if we passed rule changes and a court determined that in the course of doing that we violated the act, then those rule changes could be voided. There are also criminal penalties. Anyone who knowingly participates in a walking quorum or who knowingly participates in a meeting that is closed to the public can be subject to misdemeanor criminal penalties. And these consist of a fine of up to $500, confinement in jail for up to 6 months, or both. Some more best practices: just avoid communications that involve a quorum of members about official business that are conducted outside of a public meeting. And during an open meeting, just confine your discussion to the items specifically on the agenda. So this page just contains a few resources. These are also in your printed materials that have been given to you for today's meeting. And of course, if you ever have any questions, feel free to email me personally, or you can call the number here for our general counsel office and we can give you guidance on any questions you have. That concludes our Open Meetings Act presentation. I'll stop here. Does anyone have any questions about the Open Meetings Act at this point? Okay, hearing none, I'll go ahead and move forward. The next portion is the Administrative Procedure Act. And this is especially important given today's meeting. We'll be discussing some basic concepts that we'll be looking at putting into possible rule changes. And so this will provide sort of the guideline of how the rule change process plays out. So this is particularly important for where we're at today. So the Administrative Procedure Act, the APA as we call it, its purpose is to establish minimum standards of uniform practice and procedure for state agencies and to provide for public participation and transparency during the rulemaking process. Now, what is a rule? A rule is a statement of general applicability made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. And I know that's a lot of legalese, but that's the definition that the APA gives us of a rule. So essentially, it's policies of the agency that apply to the public. A rule excludes a statement regarding only the internal management or organization of a state agency that doesn't affect private rights or procedures. So if it's just kind of how the department runs its internal processes and it doesn't really affect any rights of public members, then it's not really considered a rule. It's just kind of an internal management policy. And when we're talking about a rule, we're talking about either a new rule, an amendment to an existing rule, or a repeal of an existing rule. So we use the term rule to include all of those things. Sources for rulemaking can come from many different things. Sometimes there are legislative changes to the law that require us to make modifications to our rules. As you'll see today, sometimes our rules come from advisory board input, such as our work group meetings that we've had. Sometimes TDLR staff can come up with ideas for a rule that we'll present to you as the board. And the agency, every state agency is required to review their rules every 4 years to make sure the rules are not obsolete and to make sure that they're still necessary. And also, any member of the public can petition for a rule. And send that petition to the agency. And on that note, when we say interested person, that is anyone who is a Texas resident, a business entity located in Texas, a governmental subdivision in Texas, or a public or private organization that is not a state agency but is located in Texas. So essentially, it's anyone in Texas. They can petition an agency for any idea they have for a rule change. This slide is going to be a sort of a flow chart that shows you how the rulemaking process plays out, and this is particularly important to today's meeting because I want to make sure we all understand the process for how rules get made and how this board plays into that process. So the first step that we're currently in is rule idea and drafting. And this is one box, but this is kind of a huge box. And, you know, we spend a lot of time on this particular step. You know, we've held 4 work group meetings since our last full advisory board meeting to discuss general concepts for what changes they would like to see. And those will be presented to you today, and we'll have brief discussions. And then we'll take the feedback we get from you today, and then we'll try to put those concepts into rule language, and then we'll come back at a future meeting and kind of look at that rule language. But before we do that, we have to do an internal review and analysis of the rule. We have to look at the fiscal impact that rule may cause on members of the citizens of the state or members of the industry that we regulate. We have to look at how it affects small businesses, how it affects rural communities. Just generally, if the rule imposes any costs on anyone, really, we have to do a very thorough analysis, and we have department staff who are dedicated to those specific analyses. Then we have to send our rule language to the governor's office, and they conduct a review with their legal staff to make sure there are no issues with anti-competitive issues and those types of things. And then we would bring the suggested language to you as the full advisory board and get your input on it. And you would have the opportunity to make a recommendation to either publish the rule or send it back to the drafting stage and make changes to it. If you do make a recommendation to go forward on the rule, we would then file the proposed rule in the Texas Register where it's published for the whole world to see, to give the public notice of what the agency is proposing to do. And that triggers a 30-day public comment period where anyone can send in any comment they have on the proposal. And then the department takes all those comments and we review them, we analyze them, and we create a summary. And we present that summary. Well, we give all the comments to you, and then we will present a summary to you at a second advisory board meeting and allow you to consider those comments and decide if we should make any changes based on those comments. And at that point, you can either recommend adoption of the rule, or you can recommend changes to the rule, send it back to the drafting stage again. Just, we have a few options at that point. Assuming you recommend that the proposed rules be adopted, that would then go to a commission meeting of our full Commission of Licensing and Regulation, which is the governing body of the department. And the commission would be presented with the proposed rule language along with the comments that have been received and whatever recommendation your advisory board has made. And if the commission decides to adopt the rule at that point, we would file an adoption notice in the Texas Register so everyone can know that the commission has adopted this rule. And then the rule would become effective on the effective date, which has to be at least 20 days from the date it's published. It can be longer than that. If we decide we want something to go into effect on January 1st or something like that, we can do that, but it has to be at least 20 days from the publication date. And I'll go ahead and stop there to see if anyone has any questions about that process. Okay, and it sounds like we don't have any, so I'll go ahead and move on. As I mentioned, every 4 years, we have to review our rules to make sure that they're still relevant. So all of our programs are on a 4-year review schedule. We start that process by publishing in the Texas Register a notice of intent to review, so everyone knows that we're going through this process and they have the opportunity, they have 30 days to submit any comments on how the public feels about whether the rules are still relevant, whether they're obsolete, whether they need changes, and those kinds of things. Our general counsel office reviews those comments and makes a recommendation to the commission as to whether the rules should be readopted. And the commission will review the rule filing and any comments and may choose to readopt the rule. And the advisory board will be presented with those same comments and may recommend any changes that we can make in future rulemaking procedures. So that concludes the Rulemaking Administrative Procedure Act presentation. These are a few resources that are also in your materials. Of course, if you have any questions, you're always free to email me or call our general counsel office. Any question on that portion of the presentation? Okay. And finally, we have the Public Information Act. And this is also sometimes referred to as the Open Records Act. And its intent is to allow access to information about the affairs of government and the official acts of public officials and employees. The Act makes all documents, records, and other information relating to official business open to the public, with some exceptions. And public information includes any electronic communication created, transmitted, received, or maintained on any device if it is in connection with official business. And again, we construe this law liberally in favor of granting requests for information. So we err on the side of transparency. So if you as a board member receive a written request for records or correspondence or anything that looks like that kind of a request, please forward that to our team. You can forward it to me or to Delia or to our Office of General Counsel immediately, as quick as you can, because we have very short deadlines to respond to those types of requests. We have to respond as soon as possible, but not later than 10 business days after receiving the request. So if you get anything, forward it along as quickly as you can. And it's important to state, we cannot ask why somebody wants those records. We can only ask for clarifications to help us identify the relevant records. And as far as exceptions to disclosure, the general rule is that there's a presumption of openness. Certain information is required to be redacted from open records, such as dates of birth, personal email addresses, personal education information, and personal health or medical information under HIPAA. These are a few resources also included in your materials. And again, you can always contact me or any of our staff if you have any questions. So that concludes my presentation. Are there any questions about anything that I've said at this point? Okay, with that, I will stop sharing my screen. If I can figure out how to. Let's see. Okay, here we go, stop sharing. Okay, so that should have worked. So that concludes this agenda item. Mr. Presiding Officer, I turn the floor over to you.
Thank you very much, Derek. An excellent presentation and good reminders. We move on now to item D, the approval of the minutes. This is going to be where we make a motion and it's second to approve the minutes of November 16th, 2020, our last meeting. Prior to doing that, does anybody have any discussion that they would like to make about the minutes? Okay, seeing as there is no discussions, I would ask someone to make a motion and someone else to make a second, please, to approve the minutes.
So motioned.
Second.
Very good. All right, Delia, could you tally the vote, please?
Yes, sir. Mr. Wyatt, I'm sorry, did you make the motion?
Rick White, yes, I did.
Okay. And Mr. Manager, you said?
Yes.
Okay, thank you. Just wanted to be. Jeffrey Alf,
Yes.
Jude Exnight,
Yes.
Kyle McNew,
In favor of approval.
Michael Matzer, Robert Richmond,
In favor.
Ricky Wyatt,
In favor.
Chris Lipton,
I approve.
Roger Bowles,
Yes, in favor.
Presiding Officer Keith Rovell,
In favor.
and motion passes. Thank you.
Thank you very much. All right, moving on to item E is our public comment section for the meeting today. The rules for this have been published with the agenda for our video conference today. We did receive, the Motorcycle Safety Advisory Board did receive 2 public comments. They were sent to the board beforehand. Now, we do not read those comments publicly. We do have one person who wished to speak under public comments. Joel Morris will have up to 3 minutes to speak, and Delia will keep time. Is Mr. Morris in the house?
In favor.
Hey, Keith.
Okay, yes. Is Mr. Morris here?
I'm here, Keith.
All right, Mr. Morris, Delia is timing. We will ask you first to please quiet your audio down in the background as we are hearing on a delay. And then you will have up to 3 minutes to speak and Delia will time. Go ahead, please.
Good morning, everybody. This is Joel Morris, San Jacinto Harley-Davidson Riding Academy. Sent out a letter and just I'm still like everybody else, really interested in where we're at on the coaches, training, all that, trying to get more coaches. That's still my Achilles heel, is not enough coaches to keep growing my program. So Chloe emailed me back yesterday, said we had 287 coaches currently right now. And then I asked her if she could let me know how many riding academy coaches we had out of that number. And she replied back that that y'all were using a different licensing system from DPS and weren't capturing that information, that I thought was kind of strange or whatever. So I'm curious as to what information, we are capturing or keeping. And, if you got my letter yesterday, that we had access to a list of coaches and being able to possibly contact them, because Harley has a new program out where we can hire a temporary coach as a C2, but I don't have any way of getting a hold of those people unless I get some help from y'all to get that list, or if y'all can send out a tweet or an email to see if any coaches might like to be a C2, and see if anybody, any state coaches would like to go to the Harley Riding Academy School to get Riding Academy certified. So, like I say, you can read the rest of my letter and all that. And then something came up today. I had a student call that signed up, said he took a class somewhere else here in town, and said that they did not do the e-course. I guess I got to thinking about it, and I'm curious if y'all can answer it in this meeting. If not, maybe somebody can call or email me. But I thought the e-course is mandatory per Texas, period. But with us doing MSF and some dealers doing total control, if you took a total control class, do they still have to take the and stuff. So I'm just, I'm still just a little confused and whatnot as to, where everybody's at on all this. But like I say, my biggest thing is still trying to find out where we at on the coach shortage, and I'm sure y'all are going to go over that in a little bit. And that's all for now. Thank you very much.
Okay, thank you, Mr. Morris. Does anybody have any questions, clarification to ask Mr. Morris at this time?
Rick White, industry rep. Can I address some of the concerns, or is that out of our jurisdiction?
Mr. Wyatt, we can't really address specifically his questions. We can ask clarifying questions if you didn't understand his comment, but we can't engage in a discussion because it's not an agenda item at this point.
Understood. Thank you.
All right. If there are no clarifying questions, then we will thank Mr. Moritz for his comments, and we will move on to our next agenda items, which are the staff reports. We'd like to begin on that with Chloe Whalen, who is the licensing manager, talking about the licensing division.
Good morning, Chairman Ravel and board members. Happy New Year. Good to see you here again for our next meeting. For the licensing report, I have two new staff members, Mr. Kenneth Clopton, started on December 1st, and Derek Hubbard, which started on January 4th. Staff continues to work from home on a rotating schedule, as well as the licensing managers coming into the office. Heading down to statistics, since our last meeting, we have renewed one motorcycle instructor. We've renewed 22 instructors, and the total population for motorcycle instructors is 287. For active ATV instructors, there have been no renewals or no new licenses issued, so that population still stands at 112. Thus far, since our last meeting, we've issued 4,070 MSB 8 certificate orders. And that concludes my report. If you have any questions, please let me know.
Yeah, are there any questions?
Rick White, industry rep. I do have a question. The MSB8 certificates, those are just the blanks that go out to the sponsors. Those are not completed certificates.
Correct. Those are the blanks, MSB8 that go out, that they give to the students once they complete the course.
All right.
I have a question, Chris Lipton, advisory board member. Chloe, you had on your information here that there was one new Rider Coach certification. I was just curious what channel that came through.
I'm sorry, can you repeat that, Mr. Lipton?
Yes, you mentioned that there was one new Rider Coach certification, and I was just curious how that came to be.
For the new applicant?
Well, I thought maybe I misunderstood. I thought there was one new certification. Is there a certification or just an application?
It's the instructor. It's just one application, the instructor that applied for a motorcycle instructor.
Okay, thank you. So they've applied, they've gone through the process to apply, but they haven't been certified yet.
For the trainings, that part I wouldn't have, but they've completed the application process, so we were able to issue them a license.
Okay, I'm still not clear.
So they met all of the application requirements that we now have in place. And so we were able to issue them a license according to the requirements that we have right now.
So does that mean that they can now conduct motorcycle safety training in the state of Texas?
Yes, sir.
Okay. It was my understanding that to achieve that, you had to go through TEAC's training, and that we didn't currently have a reciprocity agreement in place. So that's kind of why I'm asking the question, is what channel did they go through to be able to be licensed, since we haven't got those things nailed down yet? So that's what I'm curious about.
So I would have to pull the application, and then we would have to discuss that at a one-on-one or with an open records request.
Yeah, and I'll jump in here. Derek Burkhalter, TDLR. We can't go into discussions about specific licensees. I take your question, Mr. Litfin, and we will look into that and get an answer for you. I don't know the answer to that as I sit here. We will follow up with you on that.
Okay, I appreciate your answers, and I think you grasped it, Derek. It's not, I don't need any information about the particular applicant. I'm just curious as to how the mechanism that was gone through to get certified, because I didn't know there was, I wasn't aware of one that was implemented yet. So I was just curious about that. I appreciate that, and I'll look forward to your interest coming offline or later. Thank you.
Okay, Keith Ravel, presiding officer. Derek, I would appreciate getting that answer also, please.
Yes, sir, Mr. Ravel. Understood.
Are there any other questions, comments for Ms. Whalen? All right. Thank you, Chloe.
You're welcome.
Now to the Customer Service Division, and we're calling on Jacqueline Rush, the Customer Service Manager.
Good morning, board members. So the statistics that you're looking at now, I think since the last time we met, the November statistics are going to be new for you. We received 10 emails and 55 calls related to your industry. The trend continues where people are checking on license status, renewal instructions, help navigating the website, and some folks that were actually trying to reach DPS to be licensed. So that remains pretty steady. Did you have any questions on the calls or anything else?
Yes, Ms. Rush, Keith Ravel, presiding officer. I'm just curious now, these will also be from people wishing to lodge a compliment or a complaint. Has there been any kind of analysis done on the positives versus the negatives?
Can you clarify the question a little bit?
Yes, I would assume that with the customer service number, anybody that would call with a complaint or a compliment about the product they've just gotten, the class they've just taken, would address it in that way. Has there been any tally of how many complaints versus kudos that y'all have received?
Sure. I mean, we would have to look into it. I was trying to make sure that you weren't talking about enforced complaints, but you're talking about complaints on the service in general, correct?
Yes.
Yeah, so we have a mechanism where people can literally send a complaint email. So I can check into that to see if that's been used specifically for motorcycles. So I'll have to look into that and then we can get back to you on it.
Thank you.
You're welcome.
Board members, any other questions, comments? All right, since there are none at this time, thank you very, very much, Ms. Rush.
You're very welcome.
We will move on now to the Education and Examination Division, and Michael Strong, the E&E manager, has got that report for us.
Good morning, Chairman and members. Michael Strawn for Education Examination. Appreciate y'all's time and being here this morning. First exciting bit of news I wanted to provide to you all is personnel updates. I'm extremely excited that we hired somebody that most of you all, I believe, know, Mike Sconza. He used to be a former DPS and personnel for the motorcycle safety unit over there. We recently picked him up and he started with us January 4th. We've immediately thrown him into the process, really looking forward to not only how we utilize y'all's knowledge and y'all's strengths and, from y'all's history in motorcycle, but having him on the team is a huge asset. We've already been involving him in the meetings and in other processes we have. So we're extremely excited to get him involved, and you're going to start seeing more of him out, at schools, handling emails and different issues that are coming up. Certainly when we have, comments coming in and industry feedback, his expertise in this is going to be huge when it comes to, complaints or questions about how to handle certain courses. So he's extremely valuable and we're very excited to have him. Next on our list, we have statistics, and as you'll see, September was the only school that new school that we had licensed. That still remains constant at this point in time. We have no new schools for this month, and so scrolling down a little bit further, it appears everything is pretty quiet as far as all of our stats. Hopefully here soon, as we start to see our development of instructors, maybe that will translate into new schools that will come as well at that time. Now to the next agenda topic, if you don't mind. So we were going to give updates as far as projects we've been working on. The biggest project that we have been looking to undertake and here in E&E, especially in my outreach section, is to develop our outreach and our audit policy and process. Especially as I said earlier, with the addition to Mike on the team, we have already completed our checklist. We're developing the SOP. We've reached out to industry members to set up pilot processes and and potentials to come out and run these processes through the traps to establish an official audit process and get back out there, be involved in those schools, working with them to develop their training to make sure everybody's doing what they need to be doing, the ranges are up to par, and we continue to do that. We're looking forward to hopefully by the next time that we have this advisory board, that we have at least a pilot process in place and something that we're looking to sign off. So we're very excited about the progress we've made on our audit process, and you should start seeing us hopefully, especially depending upon COVID, back out in schools here very soon. We also wanted to make note for everybody that we have seen at times that instructors or schools will have an expired license. And if that is the case, they will not be able to upload course completion data into REMS at this time if that license is expired. If that happens, you are still able to issue the certificates of completion to your students, and once that license has been updated into the system, assuming this is a delay on our part, that data will be able to be uploaded at that point in time. COVID-19, kind of segueing off of that, has created kind of an unprecedented challenge here at TDLR. So we want to remind people, to renew as soon as you get a notice that you're expiring, whether that is a school or an instructor license. And if it has been more than 120 days since you mailed in your paperwork, please contact us at education@tdlr.texas.gov so that we can follow up, we can find out where your paperwork is and ensure that you're getting processed. We are doing a lot as far as working towards that to reduce those times, but always communicate with us and we're happy to look into any issues, questions, or concerns that you may have. So appreciate that. And then moving down to work group updates. As you kind of heard talked about already in this meeting, we have had several work group meetings as we continue to develop processes and rules for the industry. We are very appreciative of the time that our members have given to us, and we have had substantial growth and what we've learned and what we've accomplished. Our education examination work group, we talked about a lot, we've learned a lot. We have an upcoming training that will be issued where we're going to be talking about standards for, or that was discussed, for the standards of approval for instructor course curriculum, additional standards that we may need to have for training sites, if that was additional runoff areas, additional safety concerns, if we needed to allow certain schools to have indemnity waivers, a lot of things that really came in deep discussions from our work groups. We talked about changes to student to instructor ratio limitations, 6-to-1 versus 8-to-1, and trying to establish standards there. And again, standards of approval for changes to updates to course curriculums. Whenever we're making a rule or when we look to develop these rules with the advisory board work groups, one of our number one concerns is that we never do any damage. So if we're going to put standards for approval of the curriculum changes or updates, we want to make sure that we're not holding anybody back from being innovative or making those changes. And that's something that when you look at that bullet point, that was our key focus as far as when we're developing these rules and these processes with that work group to make sure that we're not doing. Additionally, as we continue to move forward, we have an operations and logistics work group scheduled for was scheduled for December 21st, in which we talked about a ton of other things. And I'm not going to go into extreme details because the advisory board members themselves will be going through the decisions that were made or the items that were reached for us. But during that meeting, we talked about the RIMS reporting system, alternative methods for how we report that. We went over parental consent reports or forms for if anybody was under the age of 18 and how we would handle that. Everything from requirements to limitations of those liability waivers signed for students. That was something that was done by DPS and something that was being done or is being done by the actual course providers as well. And if TDLR should consider that same regulation. We also looked at limitations of tuition fees charged by schools and students, whether TDLR needed to be involved in that or not. And then lastly, regulations related to non-instructor personnel on a range, or also known as a range aid, and if TDLR should license or provide rules for the regulations of that individual on the range itself. Again, I just want to recap. There was a lot of work done in these work groups. It was hours of great talk, great discussion. I think that we benefited a lot from our knowledge, certainly. So a heartfelt thank you to everybody, every member on the board today. With that, I believe that concludes my report, and I'm open to any questions that you will have. Mr. Ravel, I believe you're muted.
Thank you. Does anyone have any questions or comments for Mr. Strawn? All right. Thank you very much for that report. We call on Jaime Aribia right now, the enforcement prosecutor, for an update on the enforcement division.
Thank you. Good morning, Presiding Officer Ravel and board members. My name is Jaime Aribia. I'm a prosecutor with the Enforcement Division, and I will be presenting the division staff report. First, we have personnel updates. On November 6, 2020, Prosecutor Ken Sharp retired after 7 years of service with TDLR and 13 years of total service to the citizens of Texas. Ken worked briefly on the transportation team before joining the criminal history review team. Ken evaluated thousands of criminal records in an effort to protect our citizens from those not fit to hold a license due to their criminal history. Ken was very active in the department's Veterans Association. He was both a co-founder and its first commander. On December 4th, 2020, Prosecutor Michael Shirk retired after 8 years of service with TDLR and nearly 2 decades of service to the citizens of Texas. Michael was a member of the transportation team, where his enthusiasm for public service and protecting the citizens of Texas was clearly evident. He was a pleasure to work with and served as a mentor for many of our staff attorneys. Michael will be missed, but his legacy of public service will long be remembered. On January 4th, 2021, Arthur Arevalo was hired to fill the investigations manager's position. Art retired from the Austin Police Department after nearly 26 years of service. He then worked for the Travis County Sheriff's Office and more recently served as the captain with the Texas State University Police Department. We look forward to Art's contribution to the success of our team as TDLR continues to strengthen the enforcement division with staff that embraces our mission and shares our dedication to make a positive impact while serving the citizens of Texas. Now for the statistics. The statistics are for fiscal year 2021, which began on September 1st, 2020, and continues through August 31st of 2021. There are 2 columns in this report. The report contains statistics for all TDLR programs through November 2020, which is the first quarter for fiscal year 2021. You will notice the report now contains specific statistics for your program per your request during the last advisory board meeting held on November 16, 2020. And this report indicates that there is one case currently open in your specific program, and the source of that case is criminal history. That concludes my presentation, and I am available to answer any of your questions. Thank you.
Board members, do we have any questions, comments for Mr. Aribia? Okay, hearing none then, we will advance to the report from the executive office. Thank you, sir. And I call on David Gonzalez, the Deputy Executive Director.
Good morning, Presiding Officer Ravel and board members. I'm David Gonzalez, Deputy Executive Director for Licensing Services and also the liaison for this program. I'll be providing the executive report. So we've given you a few updates on COVID-19 in our past few meetings. We have maintained our status, allowing all of our staff to be able to perform their job duties from home. Those that can, not all of our staff are able to do that. The mailroom and some of our licensing staff still have to come in. And we've committed to our staff to keep a pulse on the COVID numbers, which, as y'all know, across the state have been going up. So we're being very cautious about increasing our numbers of return to office. Again, we've not been immune to the effects of COVID. Some of our agency staff have tested positive, and we've had to wrestle with the quarantining and coming up with processes to keep people even more separated and even maybe working in rotations so that there's not a full downtime of any particular division, that we always have staff that are able to keep the work flowing. As Ford alluded to earlier, we've had our struggles, but we've also offered some relief by way of offering license extensions for individual licenses expiring through December 31st. We actually went to our commission to get some authority to extend those licenses 120 days. So if there's any delay on our part, for whatever reason, the internal delays because of quarantining, we're hoping that extra extension will allow for the renewals and the processes for our backlog on our side. With the help of IT staff, we're also increasing our capabilities from home. We're getting more laptops and remote capabilities to make it more effective to be able to work from home, because that is important to keep our staff safe and keep the work flowing. Because legislative session is upon us, as of January 4th, our executive director actually has elevated our return to office readiness status for executive and some of the key staff, like our Office of Strategic Communications, where we're going to have a rotation of executive leadership in the office at the E.O. Thompson building, which is right downtown close to the Capitol, so that we'll be available should anybody need to meet with us in person, or we need to go across the street to address any issues that come up with the governor's office or the Capitol. So we're trying to lead by example, have our executive leadership available. I actually was on site Monday and Tuesday. Ms. Kaiser is actually the on-site representative today, and we'll be continuing that through the legislative session. As things heat up during session, as there's more work, we may alter that our return to office plan and have more of our staff available, but right now that's our plan. Any questions on our COVID-19 update? All right, seeing no hands or hearing none, I'm going to go to the Sunset Commission update. So for those of y'all that are interested in our agency being continued, we actually had a December 7th meeting. Our executive director and our chair of our commission, Mr. Figueroa, actually participated remotely from our North Campus office. So the Sunset hearing allowed for us to participate remotely. There was a choice they gave to us. It took them some time. We actually had our hearing delayed from previous dates that were set to December 7th. And so the meeting went well. The IT that they set up, the logistics, there was good sound and good interaction with the Sunset Commission staff. We did have a chance to reiterate to the commission members that we stand ready to implement any of the changes that were recommended in the reports. There was several issues that were proposed, and we basically reviewed those issues. Also, our opportunity to reiterate how we've been affected by COVID and our LAR legislative appropriations request exceptional items that we want to make sure that they're aware of, so that if we need more staffing and funding, that they'd be able to consider those. For those that are really interested, again, our follow-up hearing is scheduled for January 13th at 11 a.m. or upon adjournment of the House. So if you want to listen in to see how we do and what their decisions are on some of these matters, they should be sharing some of their recommendations with us at that hearing. For the public audience, if you can go to our website. We have some of this information on our website, but the best place to go for Sunset information is www.sunset.texas.gov. And that's all I have on the Sunset Commission update. Are there any questions on that? All right, Delia, if I could get you to put up the outreach statistics, if you don't mind. All right, I appreciate that. So we like to keep track of how we communicate with our staff. There have been good questions during our discussions about, Mr. Ravel, you brought it up, being able to delineate, are we getting positive or negative feedback in our interactions? These are just numbers, but they are important numbers. And if we can get that level of detail, we're going to do a better job of determining how our customer service is going. So appreciate those types of questions. But over the past 6 months, from September through December, the Motorcycle ATV Operator Safety website has had 19,548 views. That's quite a few, an average of 162 per day. 66% of those visitors accessed the site from desktop computer, while 31% did so from a smartphone and 3% from a tablet. Top reasons for visiting the site: finding a motorcycle or ATV safety school, forms and publications, finding a licensed instructor, program transfer FAQs, and order course completion certificates. Again, our website and our internet access is how we're doing most of our business. So if there's things that we need to improve upon, these are opportunities to bring them up. And looking at these numbers, if there's something else that we would expect to be higher in the list or things that we think we can do better, hearing y'all's feedback is always helpful. And that's all I have for the executive report today, unless there's additional questions or we want to follow up on anything.
Okay, board members, are there any additional questions or comments?
Presiding Officer Ravel, Mary Winston here, TDLR. I just wanted to, Jacqueline Rush has found some information for you. And it was the question about the customer service kudos or complaints. And she did a little research, and I'll just share it with you, that we have not received any customer service complaints through the Compact with Texans email for complaints. But sadly, we do not track kudos. She did say she likes the idea of tracking those kudos, so you've given us some more information to look into. That's always good, and we just wanted to give you that before we proceeded with the agenda.
Thank you very much, Mary. Any other comments, questions, folks? All right.
Rick White, Industry Rep. Request a short recess if possible.
Yes, at this time, I've got 11:04 on the clock. Let's take a 10-minute recess, and we will be back at the board at 11:14. 8:14, and we are resuming our meeting at this time. And it appears we have our quorum back. So we're going to move on to item G on our agenda, which is the discussion and possible action to recommend the approval of the criminal conviction guidelines for the motorcycle safety program. Jessica Hurtado from the enforcement prosecutor will be addressing us.
Good morning, board members. My name is Jessica Hurtado, and I am a prosecutor in the Enforcement Division. I'll be presenting the guidelines to you today. Before I begin talking about what the guidelines are used for, I'd like to briefly discuss what the guidelines are not. First, the guidelines are not administrative rules that go through the notice and comment procedure that Derek discussed during your training earlier today. Those rules go through that different process and are not what we are focused on today. Second, the guidelines are not permanent disqualifiers or bars to licensure. Just because a person has a conviction for one of the offenses that falls within the guidelines does not mean that they will be denied a license or have their license revoked. TDLR always retains the discretion to evaluate each person's individual circumstances. So how does TDLR use these guidelines? TDLR is required by Chapter 53 of the Occupations Code to adopt these guidelines, and each of our 40 programs have their own specific guidelines that are tailored to their industry. The Texas Occupations Code allows the department to deny a license application or revoke a license if a person has been convicted of an offense that directly relates to the duties and responsibilities of the licensed occupation. And as I mentioned, we have 40 different programs that we regulate. So these guidelines help us to know what types of crimes we should be looking for when reviewing an applicant or licensee's criminal history. Second, these guidelines give notice to applicants and licensees as to what crimes we consider to be directly related and gives the reasons why. We also use these guidelines in our administrative hearings to educate administrative law judges who may not be familiar with any one of our particular industries and as to what types of offenses are concerning in those industries. As I stated, these guidelines are tailored and specific for each program. For example, you won't find crimes relating to animal abuse on your guidelines because it's not a concern for your industry. However, if you wanted to become a licensed breeder, then we would clearly be concerned about a person who had such a history of abusing animals, and the guidelines for licensed breeders reflect that. At TDLR, we rely on several different laws that allow us to deny a license application or revoke a license. The primary law that we use is in Chapter 53 of the Occupations Code, which allows an agency to deny or revoke a license if the criminal conviction directly relates to the duties and responsibilities of the licensed occupation. The purpose of these guidelines is to establish those crimes which are directly related. In addition to that law, Chapter 53 of the Occupations Code also allows an agency to deny or revoke a license if a person is convicted of certain serious felony offenses listed in the Code of Criminal Procedure. These are your really bad crimes, such as murder, capital murder, aggravated robbery, trafficking of persons, sexually violent offenses, and others. These crimes often overlap with the categories of crimes in our guidelines, but sometimes they may not. We were greatly assisted by the work group members who provided us with their knowledge and insight into what the areas of concern are for your industry. On December 3rd, the work group members, Chris Litfin, Robert Rigman, Kyle McNew, and Jeff Alford all met with staff to discuss a draft version of these guidelines that had been previously prepared. The members of the work group brought up some additional areas of concern, and based on those discussions, we were able to add those additional categories of crimes to the draft guidelines that are being presented to you today. And after that meeting, the revised guidelines were again sent out to the work group members, and we were able to get their feedback a second time and ensure that we had covered all of the items raised during our meeting. Now I'd like to give you a little bit background on how this process actually works at TDLR. Each day, background checks are run on all applicants and on license holders applying to renew their license. Some portion of those individuals are sent to enforcement to have their criminal background checks evaluated. Enforcement has a criminal history team that has several legal assistants and 2 attorneys. And each day we get a stack, and sometimes it's a stack like this, and sometimes it can be a big stack. But we get that stack of background checks and we go through, and if we decide that there's nothing that we see that is of any concern, then we clear that person for their license. And I want to emphasize that the vast majority of individuals are cleared at this stage. And to illustrate that, a few numbers. For fiscal year 2020, 18,304 individuals were referred to enforcement for a review of their criminal history. Of that number, 15,487 were cleared immediately without gathering any additional information. The remaining 2,817 cases were opened for investigation. So as I said, if there's something that could be a cause for concern, we open a case for investigation, and a TDLR investigator will gather that information about all the concerning offenses, including the dates of the offenses, what the disposition was, the sentence, and sometimes we'll even get police reports or court documents that can shed light on the particular circumstances surrounding the offense. Sometimes the investigator will ask the individual to provide letters of character reference or any other evidence of rehabilitation that they may have. After that report is completed, one of the 2 attorneys on the team is assigned the case and must decide whether to clear the person and grant the license or send a notice that we intend to either deny the license application or revoke their current license. And in making that decision, we must consider the factors that are set out in Chapter 53, which include the extent and nature of the person's past criminal history, the age of the person when the crime was committed, the amount of time that has elapsed since their last criminal activity. You know, if somebody had a last crime 5 or 10 years ago, it's very likely that we're not going to take a look at that. Evidence of their work history or rehabilitative efforts, evidence of their compliance with any community supervision or letters of recommendation. Here again, a large portion of these cases may be closed and the license granted, either because we learn more about the crimes or the person provided sufficient information to close the case. And just to give you some more numbers, in fiscal year 2020, out of all applicants, 0.08% were either denied a license or had a license revoked. So we're talking about a very, very small number of individuals out of the whole pool. Now, if we do decide to send a notice and that individual disagrees with the proposed denial or revocation, they can request a hearing, which is held by the State Office of Administrative Hearings. That's another state agency. And at that hearing, an administrative law judge will take testimony and evidence, and afterwards issue what's called a proposal for decision, which will recommend to the commission how the administrative law judge believes the case should be decided. That proposal for decision is considered by the commission in an open meeting, and the commission has the final say as to whether that person should get or keep their license. Neither the ALJs nor the commission act as a rubber stamp, and they both routinely disagree with us and decide that someone should in fact receive a license. Before we go into the guidelines themselves, does anybody have any questions about the procedures or anything that I discussed? Okay, not hearing anything. We'll go now to the actual guidelines. And okay. Okay. All right. A small note before we discuss the guidelines in depth. On the document, you will see that the off-highway vehicle operator education program is also referenced. This was just an oversight by staff, and I asked that you adopt the guidelines today with the correction of removing any reference to that program. Now, when you look at the guidelines, you'll see that they are organized by categories of crimes. And that is because it would be too difficult to try and list out each and every specific crime that could come up, not only for Texas, but for all the other 49 states or any kind of federal crime. Second, you will see that the guidelines are divided by license type. One section at the beginning is for the motorcycle instructors, and then following that, you have the section for motorcycle schools. This was one of the great suggestions or recommendations we had from the work group members. And it points out and recognizes that the motorcycle instructors and the schools have different functions, and their concerns about someone's criminal history for those licenses are different. Okay, so for instruction for the instructors, you'll see here the first category is crimes involving fraud, forgery, bribery, or tampering with records. And then you'll see listed under here the reasons why those types of crimes are directly related to the duties of a motorcycle instructor. The second category includes crimes involving deceptive trade practices. These are similar to the first category, but they can involve different types of deception. And again, we have the reasonings listed as to why those crimes are directly related. Third are crimes involving the operation of a motor vehicle while intoxicated. This was a category that the work group members strongly felt needed to be included because of the great emphasis on safety that is essential to proper instruction and to the risk that an individual with a predisposition for these types of offenses would pose to the public. And again, those reasons are listed. And finally, the last category includes the crimes involving children as victims. Because minors may be students and interacting with the instructors, the work group felt that this was also a necessary category in order to protect the public. Does anybody have questions about the guidelines that we've discussed regarding motorcycle instructors? Okay, then moving on down to the motorcycle schools. You'll see that this section focuses primarily on two categories that we already discussed. Those crimes involving fraud, forgery, bribery, or tampering with records, and those crimes involving deceptive trade practices. And because the school license holder is not having the same interactions with members of the public as the instructors are, the work group felt that those other categories involving intoxication offenses and crimes against children were not directly related to holding a motorcycle school license. And we don't want to exclude anyone unnecessarily from obtaining a license. Okay, is there any questions about the guidelines for motorcycle schools or any questions at this point? Okay, well, with that one change that we discussed, I ask that you approve these criminal conviction guidelines and recommend approval by the Commission of Licensing and Regulation. And thank you for your time today.
Thank you very, very much, Ms. Hurtado. At this time, any further discussion on the presentation that we just saw? Okay, do I have a motion to recommend approval of the criminal conviction guidelines for the motorcycle safety program?
Chairman Ravel, Kyle McNoob, advisory board member, move that we approve as presented.
Thank you, Kyle. Is there a second?
Mr. Ravel, Jude Chick, Snyder Rider Rep, I second.
Okay, Delia, can you conduct a roll call on that for the votes, please?
Yes, sir. Jeffrey Alford,
Yes, to approve.
Jude Snyder,
In favor of approval.
Kyle McNew,
Move to adopt.
Michael Manser,
In favor of approval.
Robert
In favor.
Rick Wyatt,
In favor.
Chris Lipton,
I'm in favor.
Roger Bowles,
In favor.
and Presiding Officer Keith Rovell.
In favor.
Motion passes.
All right. Okay, then we move on to our next item agenda. That is agenda item H, the update and consultation on the proposal to contract with Texas A&M Engineering Extension Service, TEEX, to administer the instructor training program pursuant to Texas Transportation Code 662.005 and 662.0064. And we call on, once again, Assistant General Counsel Derek Burkhalter.
Thank you. I'm Derek Burkhalter with TDLR. I had hoped to be able to report today that we had a final agreement for this item. Unfortunately, that is not the case. The negotiations are ongoing. They are also confidential. I unfortunately also cannot explain why we do not yet have an agreement. What I can tell you is we certainly understand the frustration of the industry to not have this in place. Both agencies are actively working to reach that agreement in consultation with their legal counsel, and TDLR has been working with the work group to provide advice on those negotiations. As Mr. Litfin previously pointed out, there is not currently a mechanism to bypass the requirement to take a TEEX administered course. So when we had the licensing report and it indicated that one license had been issued, we will look into whether that is a statistical error in compiling the data or whether there was some erroneous action taken by staff in issuing that license. Again, the requirement to take a TEEX administered instructor preparation course is in law. We do not have a mechanism to bypass that. Negotiations are ongoing. I'm very confident that we will have an agreement very soon, but unfortunately that is not the case today. So with that being said, are there any questions that I might be able to answer?
Yes, Derek, Presiding Officer Keith Rovell. Will there be another work group meeting regarding this?
I cannot say with certainty. I guess it kind of depends. I can't give you a certain yes or no answer on that. All I can tell you is I feel that we are very, very close, and an agreement hopefully will be signed very soon.
Okay. Board members, questions, comments for Derek? Seeing as there are none, thank you, sir. We will move on to our work group reports for updates, discussion, and possible recommendations. Starting with Jeff Alford, talking about the Enforcement and Compliance Work Group.
Mr. Rovell, I believe we skipped agenda item I.
I'm sorry, we did. I apologize for that. And that is the update and consultation on the proposal to contract with Texas A&M Technical Institute, TTI, to research motorcycle safety and provide advocacy and education to the public on motorcycle safety issues pursuant to Texas Transportation Code 662.005 and 662.013. And again, Derek Burkhalter, Assistant General Counsel, has the floor.
Thank you again. And this will be a similar update. We do not yet have an agreement. Our resources have been focused on trying to get the TEACS agreement in place because of the urgency of that agreement. But we do expect that we will have an agreement with TTI very shortly. So that's really all I can tell you at this point. And with that, I'm open to any questions I might be able to answer.
Okay, questions, comments? Seeing as there are none, we will now go to the work group reports. Yes?
Rick White, industry rep. Question on, will the delay cause any issues with the upcoming motorcycle awareness that TTI generally spearheads?
Mr. Manser may be able to shed some light on that. I don't know if it will affect their functions. So I guess I can't really say with certainty without revealing sort of some confidential details of our discussions. But we will take into account in the agreement the shortened time period because we are at least 2 quarters into the financial year.
All right. Comments, questions? Okay, Mr. Alford with Enforcement and Compliance Work Group, you have the floor for your work group report.
Thank you, Presiding Officer. Jeff Alford, TDLR Work Group member. The Enforcement and Compliance Work Group met on December the 3rd this year, or last year rather. The work group discussed the department's draft of the criminal conviction guideline and made suggestions for edits to the draft. The final product approved by the work group is the version that was presented during item G of today's presentation. Any questions?
Group? All right. Seeing as there are no questions, call now on Rick Wyatt for the update on the work group for licensing and renewal.
Rick White, excuse me, Rick Wyatt, industry representative for TLNR. The licensing and renewal work group met on December 16, 2020, and we discussed the following concepts. With regard to out-of-state applicants for instructor license, excuse me, sorry about that. With regard to out-of-state applicants for an instructor license, the work group agreed that possible alternative eligibility requirements could be that an applicant must, 1, possess a current out-of-state license or certification allowing the applicant to teach a curriculum approved for use in Texas. 2, have instructed courses for at least 1 year, and 3, have instructed both classroom and range portions for at least 6 courses. We felt this was necessary to prevent just some that were just coaching range only or classroom only. The work group also then discussed adding an additional requirement for the instructor license that requires the applicant to not have a conviction for DWI or criminally negligent homicide in the past 7 years. This would match the current standards for the parent-taught driver education. Also, there would be a grandfather clause or a cutoff date so as not to impact a currently licensed instructor. With regards to the motorcycle courses on military bases, the work group agreed the training does not result, the work group agreed that if the training does not result in the issuance of a TDLR completion certificate, an instructor license is not required. And if instructors could get licensed and then use TDLR completion certificates. This mainly is because military is federal and separate from state regulation. And finally, with regard to licensing or approval of range aids, the attorney informed the work group that TDLR does not have the authority to license or approve range aids, so our work group made no recommendations. That's all I have. Any questions, comments, concerns? If not, I pass it back to Mr. Rovell.
Very good, board members. And we move now to our operations and logistics work group, and I'm calling on Dr. Michael Manser with that report.
Good morning, everyone. This is Michael Manser. I'm the TTI rep reporting out on the operations and logistics issues. We met on December 21st, 2020 and covered 5 separate topics, and I want to just briefly review those here. The first topic that we reviewed related to duplicate copies of the certificates issued to students who've either lost their certificate for course completion, or they were destroyed, or otherwise something that has disappeared or other. The current rule requires that the duplicate certificate bears the same certificate number as the original, so a rule change would be necessary if we want to allow schools to issue a new certificate number. Some of the items we've talked about around that include there were some concerns about the potential for fraud at schools for issued blank certificates, where the old certificate numbers can just be filled in. One suggestion was to reduce the number of lost and lost certificates, destroyed certificates, is to impose a fee on students who may have that happen. So if they come back to a school provider and asking for a new certificate, hopefully a fee would encourage them to keep their current certificate. The challenge is that many schools have gotten a lot of negative feedback when they try to incorporate this practice. So no further discussion move forward on that particular topic. The group agreed to maintain the current process of providing schools with blank certificates until we can transition to an electronic system of physical certificates will be unnecessary. And Ford Strong talked about that at one of the previous board meetings about TDLR effort to move in that direction. So we're looking forward to that. The second topic that we discussed was possible regulations for non-instructor personnel on the range. Oftentimes these are considered or named range aides, people that can help out. The department's attorney explained that TDLR does not have the authority to license or do background checks on these individuals, but that TDLR can create general rules for the range that schools and instructors must abide by. Some in the working group felt that certain individuals who are enrolled as an instructor in the instructor preparation course could benefit from being able to assist on the range, but it should be limited to those individuals alone, and they should not be doing any instructor because they do not yet have an instructor certificate. The group agreed to gather some additional information as to what and who the school insurance policies will cover, and that will help shed some light on whether a specific rule is necessary in this case. So it may be that insurance expresses for those people anyhow, so that there wouldn't be a need for a rule. A third topic that we addressed was the notion of parental consent. Specifically, should a parental consent form be required for students of a minority age? And generally, the consensus was that yes, in some way, shape, or form, the parent or guardian must be informed that they are taking a course. The group agreed that this is also necessary because minors do not have the legal right to contact by themselves. So we should add this requirement to the rule. It was noted that many schools likely are already doing this, requiring parental consent. So we'll continue to work on this particular topic. We also considered possible rules as to any legal waivers that schools should or should not require during enrollment. We generally agreed that this was an issue for insurance and curriculum providers, and the rule should probably remain silent on this particular issue, at least for now. Finally, the topic of tuition caps was raised. The group considered whether there should actually be a cap on the amount of tuition a school may charge for students for classes. The group agreed that there should not be a cap and that schools should be free to charge tuition based on free market principles. So again, there is no cap currently on the amount that a provider can charge for class. That's the end of my report.
All right. Board members, questions, comments?
I have a comment. Just a comment. While you're considering range aids on the range. My comment is to, when you're crafting that information, also consider that occasionally we have to have deaf interpreters on the range. And generally I keep everybody off the range. It's not a student or an instructor. Range aids, I think everybody understands very well. I just wanted to comment that there's occasionally a need for us to have a deaf interpreter on the range, and just didn't want regulations or restrictions or rules to preclude that from happening. Thank you.
Very good point. Thanks, Chris.
Okay, are there other questions or comments for Michael? Very good. Thank you. And finally, for our education and examination work group, Roger Bowles has the report.
Thank you, Keith. Roger Bowles, the Education and Work Group member. The Education and Examination Work Group met on December 17th, 2020. The work group discussed possible standards for instructor preparation courses and determined that the course must prepare a person to competently teach a course that meets the NHTSA standards for entry-level courses. The standards should not be too restrictive to allow for enhancement of the course, and the standards should include common elements of the currently approved courses. The work group discussed possible changes to the standards for training sites, including a requirement for range runoff space of 20 feet or more based on the physical obstacles surrounding the range. This could include a waiver process for school to show how it will mitigate danger if the runoff requirements cannot be met on a particular range. The work group will look at runoff requirements in currently approved courses to help determine the appropriate standards. The group also discussed clarifying that the classroom does not have to be a building. Classroom training could take place in a remote classroom or in a tent or trailer, etc., so that so long as it has all the necessary equipment to present materials. The work group discussed possible changes to course requirements, including clarifying that students must pass a knowledge exam and skills tests prior to issuance of a course completion certificate, and creating a standardized scoring sheet, but this may not be possible due to different curriculum scoring methods, so the work group did not recommend this change. The work group discussed whether there should be a rule addressing retests of students. The group agreed that schools should be allowed one or more retests as long as they make their policy clear to students up front. The group also agreed that schools and instructors should also have the ability to remove students who are a danger to themselves or others. With regard to student to instructor ratio limitations, the group discussed making the rule just 8-to-1 for all instructors, but there would need to be some evidence that this would not affect safety. The group will attempt to gather more information on this issue. And that's all I have for this report, Chairman Revelle. Thank you.
Thank you, Roger. Board, questions, comments?
Jeff Alford, TDLR, advisory board member.
Rick White, I have a question.
Mr. Bowles, one thing I wanted to ask you about, was it considered across curriculum types as far as the 8-to-1 certification?
Okay, I don't think he heard you, Jeff. Could you repeat that, please?
Yes, Mr. Bowles, regarding the 8-to-1 certification across the board, is that regardless of curriculum type?
I don't believe it was. I believe it was across the board for all of them. I don't know if there's a restriction for depending on, well, I think we discussed that between MSF and Total Control, but I don't believe it was in regard to one particular curriculum.
This is Michael Strawn. I can weigh in on that if needed.
Oh, sure.
So the discussion that was had was that That standard was a Texas standard that was implemented and would not be curriculum specific on that decision. Curriculum providers could always still have their own requirements that they would set forth from a TDLR standard. Any rule that we would make would be not curriculum specific. It would be general for all curriculums that are out there. Standards for every. I hope that answered your question.
Yes, thank you. The reason I ask is because there's still one curriculum type that is limited in RIMS. We've submitted trouble tickets to get that addressed, but it has not been addressed as of yet. It's still pending in the system.
Mr. Alford, if you would like to email me, we can always work with the RIMS individuals as well on y'all's behalf and see if there's anything we can do on that front.
Thank you. I'll follow up with it.
All right. Any additional questions, comments?
So just to clarify, I don't know if I missed it, but is where we're at with this that you can only teach 6 students per coach until you've taught 7 classes, and then you can start teaching 8 students per coach? Is that where we're at?
Derek Burkhalter, TDLR, that is the current rule. That's correct.
Thank you.
I have a question. Rick Wyatt, I have a question.
Yes, sir.
In regards to the range safety runoff, are we changing it to a minimum of 20 feet? Because I know there are DPS standards depending on obstacles and such. That 20 was the absolute minimum with no obstacles, 30 foot, 40 foot to hard objects, so forth, so forth. So I understand we're just going to a plain 20-foot safety runoff. Is that correct?
Derek Burkhalter, TDLR. We did not make any decisions on that particular issue. We wanted to look closely at what the current curriculums require. If you have any thoughts on that particular issue, I think now would be a good time to bring those forward.
Rick White, TDLR rep. Kind of caught between yes and no. I do believe 20 foot would be the absolute minimum as a range paints, DPS range painter before this all switched over. There were some guidelines advising 30 feet to a light pole, then 40 feet to a hard object such as a building. I know that was limiting some ranges. This is on an MSF curriculum. I'm not sure what total controls is. Maybe Mr. Rovell can weigh in as well, or even Jeffrey. I think it might be a case-by-case basis on recommendations for the runoff. So I'm kind of torn between both. Sorry.
Jeff offered. So if you go with what Rick was saying, MSF set the 20-foot recommendation as their minimum standard. DPS adopted additional standards. At this time, I do not believe additional standards are required. It does put a cumbersome burden on how far from a tree stump I need to be, how far from a curb I need to be, how far from X, Y, and Z I need to be, how far from potential traffic I need to be, because there could be a car eventually someday that I need to block for and have a certain runoff to. For the sake of this board and the simplification of everything that we're going for, 20 feet should be 20 feet, should be 20 feet.
Okay. Keith Rovell, presiding officer, TDLR Advisory Board. I did have the opportunity to speak to one of the curriculum developers for the MSF, and they did indicate that their recommendation is what Mr. Alford just said. They have done research and discovered that increasing it to 30 or 40 feet merely adds speed to the impact. And they have found that lowering it down to 20 feet is standard all over. Should someone impact a curb or a wall or whatever, it will be at a lower speed and actually safer. And that is through several years of research. And I did send that information over to Mr. Burkhalter and to Mr. Strawn. Chris.
Chris Litvin, Advisory Board Member. Just my 2 cents on this. The curriculum providers' requirements are the curriculum providers' requirements. And if it's safe at a certain foot distance of runoff for every other state, I'm not sure our obstacles and issues are any different in the state of Texas. And the only other comment I'll make is I've been doing this for 15 years, and as you guys all know on the board now at TDLR, we've talked a lot about the most pressing issue being the shortage of rider coaches. But until now, the most pressing issue for the last 15 years has been the shortage of applicable parking lot space to conduct the course on. There's a lot of areas of the state and areas of need for safety training where parking lot space is in extremely short supply. And I can't tell you how many potential ranges I've looked at over the last 15 years that almost make the requirement. There's one light pole that's just too close, or there's one corner with a fence, and I couldn't do it. And therefore I couldn't provide training to that area of the state or that area of need. And you'd be surprised how much 10 or 20 feet on one side of a range will open up more opportunities for parking lots to be used for safety training. So that's my input of the process.
Rick Wyatt, industry rep. Given what with Mr. Rovell and Chris have put into, I changed my mind. I'm good with 20 feet. It makes perfect sense.
And the other thing is, as a sponsor, my biggest fear is liability. So if there's I'm not saying all sponsors can be trusted or should be trusted to govern themselves in a responsible manner. That's what TDLR is here for. That's why we have rules. But if it would sure cause me pause to try to cram a range in someplace that I didn't think was safe. I mean, I've got a lot to lose. I wouldn't want to do that. It's the exact opposite of the best interest of being a safety training provider. Not to say that some sponsors I've known in the past wouldn't do that, but there's definitely a healthy enforcement in my mind to not open a range that's unsafe. And I think there's also a healthy enforcement, natural enforcement in the free market for rider coaches. Again, there's all different kind of rider coaches, good, bad, and ugly, but most of them are here for the right reason. They want to be safe, and they don't want to be liable for people having accidents either. So, I mean, if a sponsor were to put in a range that was unsafe, I would assume have a lot of pushback from rider coaches saying, I don't have any desire to teach on this range. It's not safe. Not to say that 20 feet isn't safe enough, just an argument for falling back to the curriculum providers' requirements on runoff space.
Okay, any additional comments from the floor? All right. Okay, we move to item K on the agenda, the recommendations for agenda items for the next board meeting. Board, are there any recommendations for our next meeting of things that you would like brought up and discussed? Okay, seeing no hands up, hearing no input, we'll move to L, the discussion of the date, time, and location of the next board meeting. We will need to poll the board for the next meeting date and time. So what are your requests, recommendations, requirements for our next meeting?
Mr. Rovell, Mary Winston, TDLR.
Yes.
At this time, we can we don't have to take a date at this time. We will have Delia give everyone an email, a call. If we have further action items on down the road, David's raising his hand. We're still in negotiations for different things, but so we will have action items to meet on. And closer to that time, we can contact members of the board to check your availability.
Excellent. Would everyone agree that 10 o'clock in the morning seems to be working out as a good time for a meeting?
Yes.
All right. Very good. Any additional input, questions on that?
I just wanted to add to be David Gonzalez, TDLR. I just wanted to add to be respectful of y'all's time. We've been working on that agreement. Just want to make sure that the next meeting we're able to have that one. So we'll schedule according to the progress we made, which again, Derek said it, we're really close.
Excellent. All right, if there are no further comments, questions, inputs, then we are at the point of adjournment. I'd like to thank everybody who attended the meeting. Right now, it is 11:59, and we call this meeting of the Texas Department of Licensing and Regulations Advisory Board to its close. Thank you all.